Hey, J-Bo Nation, shaming of Jay. He's not a dopey dumb bitch. He gets laid. The court jester, the court DJ. It's time to dive into the case. To the case.
Oh, gotta turn that off. Hold on, guys. Boom.
Oh,
What's up, everybody?
what is happening? Good morning, man. Just kidding. What's up, y'all? Let's go. Let's go. A little trial action.
Little of the first dual stream Jay and Not So Silent Bob, folks. Excited about this. We're both covering this, so why not? And you got to leave early today, so
I do. So you'll have to cover the banner tomorrow. I'm gonna try to get Allison to jump on with you for at least some of the day tomorrow. But yeah, what we'll do, we're gonna dual stream to both of our channels. We know we have a ton of crossover, like followers, subs, like on both camps. So it would be really cool if you're subs to our channel. Make sure you're not only subbing to Jay's channel, but go over there and hang in that chat and vice versa. Because we definitely have some folks that will be subbing to Jay as you grow to love him like we all do. So make sure that you're subbing to him if you're followers and subs of Defense Diaries, and go over to their chat and hang. You'll see there's a ton of us that are. We're very family oriented over here, so we have a lot of people that are and that sub to us both. But it'll be cool. Like I'm looking forward to it, and we'll have a blast, man.
Absolutely, and vice versa, folks. If you're new, you're probably, if you're following me, know about Bob. But if you don't, we have a lot of new subscribers lately. Make sure you're checking out Bob's YouTube. Same thing. Check out his chat, like, comment. Also, of course, the podcast. That's his main game, folks. The podcast. So check out Defense Diaries and on wherever it's available. So I'm sure the mods will share the links. Check it out. So yeah, and I'm sure, Bob, you'll probably be doing, in addition to some of the live streams at night, you'll probably be doing some kind of breaking stuff down with Allie and stuff just on your own page, probably, right?
Yeah, for sure. Yeah, for sure. Definitely in terms of, because so what my schedule is, I'm actually flying out to. I've got a story. So I had posted where I'm going. I'm going with CrimeCon. To Optum Labs, and I had tweeted about it, and they said, hey, can you pull that back? So I don't think it's supposed to be super secret.
It's supposed to be a little secret.
I don't know, man. But so I was excited about it. I'm excited about getting in there because we're getting kind of like a tour of the lab, and they do amazing work, and so I'm really pumped about it. So I had booked my airfare like late. Like right when we got back from Jam Cruise, I'm like, oh my God, I got to book my airfare. So I'm like, book my flights to Dallas. And yesterday I'm like, and I knew all along that it was like in the Woodlands, but it wasn't registering because I still had Jam Cruise brain fog, which unless you go to Jam Cruise, you just don't understand what that is. Cause it's like the music plays all night and it like ends at 5 a.m. like on a cruise ship. So every day. So you have to try to understand what I'm trying to say to you. It's like Jazz Fest on a boat, So I don't go to bed until like 7, 8 a.m. So you sleep through the day. It's so you can kind of understand. So I get back, I have brain fog a little bit from that. And so I booked my airfare. And then Mandy, our Mandy, one of our, amazing mods who we love so
The
dearly.
best.
She's like, oh, so you're flying to Dallas and you're driving to Houston. I'm like, oh my God. So I'm like, oh my God. And I had paid like an exorbitant rate for my airfare because I booked late. Like I think it was to get down to Dallas was like $600, like just
Wow.
for economy. So I'm like, oh my God. So I look at him, and of course I'm supposed to be flying to Houston, which is a 3.5 hour drive. So yeah, I was flying to the wrong city, dude. Like if Mandy had not sent me that
Holy
text,
shit.
I'm flying into Dallas. I'm getting off the plane, all, hey, what's going on? How you doing? What's going on? And then realizing I'm 3.5 hours away from where I'm supposed to be.
Holy
So,
shit.
yeah, dude, it was beyond fucked. So like I get, obviously I was able to switch a flight, which cost me another $200. So yeah, that was it was an expensive day yesterday. But
So by the way, folks, just so you don't think we're missing anything, I'm gonna make sure I have this right there, but they haven't started yet. But let me just make sure I have this set up right. There we go. And check
there we
out Bob.
go.
Check out what Mandy made. I hope this. I'm learning, guys. StreamYard is what I first streamed on, but I haven't used it for a while, so I'm trying to learn it here. That's why the thumbnail came on. Let's see if this works. Mandy made this. See, I don't know if this is gonna work. Let's say show. Look at that. Look at that. Mandy made. How good is that?
Beautiful. I love that. That is just beautiful. What a thing of beauty.
And I have one. Go ahead, Bob.
So did you I know you jumped on for at least a day of Crumbley with me or Allie, right?
Yeah.
You did?
Mm-hmm.
Yeah. So like just kind of a primer on this case and the reason that I had wanted to, and I didn't stream that from the get. Like I jumped in and started streaming Jennifer Crumbley's case the day that she was testifying. All right. So I didn't go through and stream the entire state's case. This time we're going to do it all. You'll be doing it all. When I get back into town, I'll start streaming on Monday. So like I said, you'll have to carry our banner tomorrow. And then when I'm back, we'll dual stream again and go through the trial. But I originally was so interested in this trial because of the ramifications that it's going to have and that trial had and will have in the future on parents being held responsible for their kids' actions for things that they do outside of their parents' presence. And I kept saying it in that case because people were sleeping on that case. They weren't understanding the significance of it. And me as a criminal defense attorney for a couple of decades, I knew it was up. I knew it. And in terms of what the state will now be able to do, because parents had been charged for various things, over the course of the years for these school shootings, but they had never been charged under a homicide statute. And just understand that this involuntary manslaughter, which is the primary charge, 4 counts of it, is a homicide. Okay. It just falls, you typically have your first degree, your second degree, voluntary manslaughter, and then involuntary manslaughter. So this falls they're being charged with the homicides themselves. They're just being charged with the lowest level. Now, the difference being with first degree and second degree, there's intent there. There's malice aforethought you need for first degree where it's premeditated and you're going in. Even with second degree, the intent has to have been to kill, so that is taken out of the equation as far as the state's concerned. And it's a reckless disregard type standard that the state needs to prove in these cases. And this is not going to be a rerun of what we saw with Jennifer Crumbley's case. This is not going to be all the same evidence. The defense was fighting very, very hard to keep out Ethan's his journal entries, which y'all, when you start seeing these journal entries, oh my God, it's like it's terrifying and it's devastatingly sad that this kid's head was where it was at. And he was going through it like for real, It's like you never want to think about, kind of what's happening through, in the minds of a perpetrator. But this case is so different than like our typical, like when we get to Koberger, we're never going to know what was going through that guy's mind. He's not going to testify at trial, or at least I don't think he is. But like in a case like this, where you've got a 15-year-old at the time who's writing journal entries, and we're seeing into what his mindset is, it's like, it's crazy. The shit that he's writing in the journal. And the question becomes, did the parents have access to the journal? I don't think that they did. Like, I don't think that they were digging around in his room and going through the journal. I mean, if the state is able to put on evidence that they had somehow gotten their hands and read the journal and then ignored, on top of everything else they're going to be putting into evidence in this case, everyone's going to be losing their minds, because they'll be like, oh my God, how could you read this journal and not realize that your kid needed help like immediately? So, but they're allowing that in, where they didn't allow certain text messages in, and the journal entries were not allowed into evidence in Jennifer's case. So, and I'm not sure if we're in front of the same judge. If Dizzy's in here, she'll know. I'm because of the difference in terms of what was allowed in, I'm thinking not, because like, and that just goes to show you how I'm always talking about that the things that are litigated prior to trial, that's where the real war is in any case. Like, people are always, why? Same judge. No shit. Wow. I'm curious as to why she's allowing for that evidence to get in this trial, but she ruled against it in Jennifer's trial. That's super interesting. Dizzy, did you put that in our in the Discord? Like, is that one of the filings that's in there? Because I'd love to be able to read that to explain to y'all like what the difference is. But going back to my point, it's like the judge's role in the middle, in the beginning and the middle of the case prior to trial, is to be the gatekeeper of evidence, to determine what's going to be admissible and what's going to be inadmissible at trial. There's certain things that they're trying to figure out at that time, at the time of trial, but most of it is litigated prior to, which is oftentimes what causes the huge gap in time from date of arrest to date of trial. Okay, so it's like, because people are always like, why does it take 2 years, 3 years to get to trial? There's a shit ton of work that has to be done in these cases, and it has to be done. And we're not just talking about going through the discovery by both sides, but we're talking about all of the pretrial litigations, all the pretrial motions have to be litigated, and those take time in order to get to where we need to get with the trial. So we'll see. But like I'm saying, there's going to be a vast difference between this trial and Jennifer's, because we know that James is the one who brought Ethan with him when they bought the gun. There's different communications between Ethan and his father. There's just a lot of different scenarios that go on where they didn't apply to James in Jennifer's trial and vice versa. There's going to be things that applied to James in terms of his relationship, his knowledge of what he may or may not have known from, his son going into the day of the shooting. But the one thing that's going to remain constant for both of them is that math test, which for me was the thing that just put me over the edge. It's such a difficult case, because and you'll see, and we're going to remind everybody in both chats, be cool. Just be cool, be civil. You can debate the issues. Just be civil. We will time you out if you start name calling, if it degrades into, something ugly. We're going to put you in timeout. Use your words. Be civil. If you have an argument, if you're on opposite sides of this issue, and there are going to be people on opposite sides of this. There are people that are like, there's no way that the government should be charging parents for what their kids are doing outside of their presence. It's crazy. Now, and I tried to explain after that verdict came down, which was the correct verdict, in my opinion. I think that they were on the hook. They should have known what was going on. They should have pulled their kid out of school that day. Jay, you and I talked about it. It was, that math test was so shocking, and when your kid's writing in all bold, help me, I can't stop the thoughts, and just everything that was on that page was, like I said, I wouldn't have cared. Oh, it looks like we're getting ready to roll. All right, so I'll shut up. Let's listen to openings.
This stream is glitching. It turned off at one point. Now it's turning off again.
Oh, great.
Dude, I don't know what's going on with their stream. This happened. I went to Court TV. It's now. Oh, this is not.
Oh boy,
not a good start.
Yeah, well, I mean, the one thing we know.
James Crumbley, case number 22.
Can everyone hear that? I hope.
989 FH.
Thank you. Good morning, Mark.
I can.
Okay, good.
Donald, on behalf of the people.
Good morning, Your Honor. David Williams on behalf of the people.
Good morning, Your Honor. Marielle Lehman on behalf of James Crumbley, who is standing to my left.
Good morning. Mr. Crumbley, can you hear us?
Yes, I can.
All right, you can be seated. I was here last night, and I have a few rulings for you. The first would be about, I believe, about Exhibit 45, 52, and 62. And those all have to do with texts from the shooter to Jennifer Crumbley during time periods when the defendant and his wife were also taking photos of themselves at a horse farm together. At least that's what the metadata and the GPS shows. So I reviewed 62.
Boosting the audio.
Good man.
And the court finds that those texts would not be admissible because they are between the shooter and his mother. There's no information whatsoever, with the exception of the fact that dad is with his wife, as demonstrated by pictures and texts and GPS and metadata and all those things, all those tools that are being used by the prosecutor's office to track people's movements in this case. So they are together, but there's no evidence whatsoever that dad was on the receiving end of that text. And in fact, I know that in both 52 and 62, the statement from Jennifer Crumbley appears, "Where's your dad?" So I don't find that there's enough support to believe that Mr. Crumbley was aware of these texts. He could have been aware of these texts. We just don't know. And because of that, those texts will not be admitted. And that also makes, I think, some of the information at the horse barn inadmissible. Clearly, if Mr. Crumbley were to testify, or if it became relevant, I can see the prosecutor saying, well, do you raise horses? Did you spend a lot of time with your wife horseback riding, whatever it might be? So the pictures of the defendant and his co-defendant at the horse farm might be relevant and might come in for other reasons. But the texts between the shooter and his mother will not be admitted because there's no evidence that the defendant knew about those. So that's that.
There you go. It's a big ruling.
About, Exhibit 78. Exhibit 78 is in.
Just pausing to let you guys know, I have the audio boost 500%. I'm trying, guys.
Yeah, Jay, and she did not have a mic during Jennifer's trial either. For whatever reason, they've decided not to give the judge a mic. So with her, it's going to be more brutal than with the attorneys.
And it's between the shooter and his friend. And it's a text that says, "Hey man, times have gotten rough ever since you left. I don't know if you're dead or you moved away, but I hope you're doing well. I'm about to do something really bad, and there's no turning back, so I'll probably never be able to see you again. I hope the best for you, and I'm sorry for anything I've ever done." And that's dated November 30th, 2021 at 8:21 in the morning, the date of the shooting. And it's to the shooter's friend, who's been previously not identified by name, but identified in this case. So I read a series of cases, including the case submitted by the prosecutor in this matter, to indicate that there is an exception in this matter. But there's not, but this is not hearsay evidence. I read a series of cases interpreting that issue. And one of those is People versus Stubble. I think it's 149 Michigan at 42. In that case, hearsay testimony was given by a prosecuting witness to testify that the defendant had approached her several times to discuss prostitution. And in that matter, the challenge to the evidence concerned the witness's testimony that one of the older men propositioned her friend. So this text in Exhibit 78 is offered by the prosecution under 8033. 8033 applies as an exception to the hearsay rule if the declarant's state of mind is at issue in the case. That's also stated in People versus Lucas 360 Northwest 2nd 162. Also a Michigan case. This one's from 1984. People versus Lucas. That also says the court's ruling that the testimony was admissible under the state of mind exception to the hearsay rule pursuant to MRE 8033 was also error. Only when the declarant's state of mind is an issue in the case is evidence of his state of mind admissible. In Lucas, they asked about the state of mind of the deputy in the case. And in that case, they determined that the state of mind of the deputy, who was one of the officers in the case, was not at issue. Then there's People versus Fisher, 449, Michigan 441. I believe that's a case that the prosecutor relied on. That case also says, talks about statements and marital discord. In that case was the issue. I believe it was a murder, husband and wife. And in that case, Fisher says, in the case at hand, marital discord, motive, and premeditation are all an issue. Thus, the statements of the victim wife are admissible to show the effect they had on the defendant husband. They were found admissible under a state of mind exception to the hearsay rule. I'm not going to admit People 78 because the defendant's, although the defendant's state of mind in this case might be admissible, the shooter's state of mind is not at issue. We all know the shooter's state of mind on November 30th of 2021. Additionally, there were requests for Facebook messages. I believe those are 160. 161 was ruled on, am I correct?
Yes, Judge. I think it was 118, 153.
I think, was it 133?
Oh, sorry, 118, 133, and 153.
All right. So I'm not going to go on 133 right now. There's something else I want to look into, but I find that 118 prosecutor notes 801C. I believe that entire chain is hearsay and
They just need to get the judge a mic. She doesn't need a megaphone. She needs a mic. I don't understand why they didn't put a mic there this trial. They had to know her volume was low.
I have 133, but I'm gonna pass on. I'm gonna have to look at 153 again.
It's the last text in 118, 153. They're the same text conversation. Once it's just a different portion. That's the last text. It's the text from Jennifer Crumbley that says Ethan, don't do it.
All right. I can get back to you on that, right? You don't need to know. Okay. So with regard to 133 and 153, I will continue my homework assignment.
Thank you, Judge. Just want to recap, make sure the record's clear. The court's ruled on exhibits 45, 52, 62 today,
Correct.
78 today as well.
Correct.
Yesterday, 308, 321. Those are two different photographs ruled inadmissible yesterday. We redacted photographs 258, 259, and 260. They were an issue. We gave a copy to the defense counsel this morning.
Okay.
We agreed to limit exhibit 80 yesterday. That's the DoorDash text message conversation, just the 26th to 30th of November. And the rest were ruled to be admissible yesterday.
Is that your understanding as well?
Yes, Your Honor.
The court's reserve on 133,
133 and 153, and you know, we're ruling before openings for those.
I do not, Your Honor. And I'm sorry, Mr. Keys, did you indicate 118 was also not admissible? Was ruled on
I
today?
should have, yeah.
Okay.
I also wanted to ask you, there was some discussion yesterday that members of the media have requested a copy of the questionnaire that was provided to the jurors. I don't have a feeling about it either way, but if you agree to release it, I will. If you don't, I won't. So, I don't.
I really don't have an opinion. Now that the jury's impaneled, I don't see an issue. Why not?
The defense also does not have an opinion on it, Your Honor.
All right, so anybody who wants one from email, the chambers, and we'll give it to you. All right. So. We're adjourning.
We have one more issue. When we were approached her.
Oh God. While they approach, I just want to, Bob, you had asked about a document. All the documents are in Dizzy and the amazing docket doctor Dizzy and Tracy made a Discord called Seeking Justice. If you guys share that link, all the documents are over there, guys. Check out that. Not only does that Discord have like all cases, but it's great for notifications for me, for Bob, for Publicly Buzzed, for Joe Jacklone. Like it, YouTube doesn't always notify you. Their Discord does, folks. So
it's amazing. It's amazing. They like Dizzy does the digging for all of us, and she gets all of the filings on all of the cases. So it's the spot to go. If you're into the papers, that's the spot to get the papers. No question about it.
By the way, Bob, I figured out I only have one. You guys know I typically, or folks maybe not know from Bob's show, but I typically have a lot of sound effects and stuff coming in, which I can't do so much, but I figured out I can do sound effects, Bob. I got one so far. You ready for it? I think you'll like it. Here we go.
Say what again? Say what again? I dare you. I double dare you, motherfucker. Say what one more goddamn time. Say what again? Say what?
I gotta get
again,
more
dude. Anything with Sam from Pulp Fiction, I'm down. I'm here for it. You know what I mean?
Love that movie.
Great. Oh, so good.
Personally, my favorite movie of all time is mine.
Yeah, it's a top 5 for me. It's just like.
Well, isn't yours the movie that just yesterday, I think, was 26 years ago released? The Big Lebowski. Isn't that your top? Or
that's my favorite comedy of all time.
Okay.
So, but like my favorite, like by far, that's my favorite. Like my test, my friendship test is very simple. I ask people like, if I'm like broing out with somebody that I meet somewhere, I'm like, oh, hey man, do you like the Big Lebowski? If they're like, nah, I know that there's no future for us as bros. So it works every time. It's like a certain sense of humor that you have to enjoy the Big Lebowski. Because for me, line for line, it's the funniest movie ever written. And everybody in that crushed it. Plus it's the Coen brothers. I love the Coen brothers. Yeah. But yeah, like top 5 movies. We'll have to have a stream with that sometime. Like I've got, you've got the Godfather in there, and it's tough. It's tough. It's like I'm a movie buff, you know what I mean? So I've watched a lot of movies in my time, and it's Shawshank. It's like Shawshank is like one of my absolute favorite movies. I watch it a couple times a year. Like every one of my kids, like I couldn't wait because there's only one really like kind of like graphic, not in the sense of what they show, but what they're talking about happening in Shawshank. It's the shower scene where where they get Andy trapped in the shower,
Yeah.
and Boggs is, doing what he's doing. And, so like by the time my kids are like 9, all my kids have watched Shawshank because I love Shawshank. It's such an important movie, and it's beautiful, and it's so well done. It's such a great flick.
You know what I just introduced my sons to, which they never seen before, and I was so proud to watch with them? Rudy. We watched Rudy together. And dude, you want to know something? I never realized until I watched it this time. I knew Jon Favreau was in
I
it.
told you that, dude. You didn't
I knew
realize
Favreau,
that.
but I was oblivious to
Vince
the fact
Vaughn.
that Vince Vaughn was in
Yes,
it.
I told you
I didn't
that
realize he was
too.
the tailback.
Yeah, when we watched, what did we watch? Which had the Vince Vaughn.
Elf,
When we
maybe?
watched no, did you come out when we watched Swingers? Right, we watched that together.
Oh, Swingers, maybe.
No,
I
was it
wasn't on for
you?
Swingers. That was
Oh,
that
me
was
and
Steve
Publicly
and
Buzz. I thought you were on with us. So maybe I told those guys. Yeah, I was like a little known fact that Favreau played D-Bop, and then
that I
Vince
knew.
Vaughn. Vince Vaughn was the
dick
he
to
was.
him at first, and then like is nice to him. I knew about that character, but I'm like, holy shit, that's Vince Vaughn.
Yeah, man. Like that's when they met.
Is it? That's when they met. Okay.
Yeah, so Favreau wrote Swingers, the script, while he was moving to California. So
Wow.
and he had met Vaughn on the set, and they became fast friends. He's like, "Yo, dude, I got a
That's
role
cool.
for you, bro." So
That's so cool.
Oh yeah, it's great. It's a great story.
Against one of your fellow citizens.
Great camera work here.
Swear to perform your duty to try the case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try the case justly and reach a true verdict. Here is your oath. Do each of you solemnly swear or affirm that in this action now before the court, you will justly decide the questions submitted to you, that unless you're discharged by the court and from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instructions of the court. So help you God. Thank you. Thank you. I appreciate you being on time. I do. I have to give you some initial instructions, and then we're going through it today, all right? And don't try to write down what I say because I speak way too quickly, and because you're going to get a full copy of these instructions when you go to the jury, all right? I'm going to explain to you some of the legal principles you'll need to follow during the trial. I'm going to tell you the elements of the charge. The defendant is charged with 4 counts of involuntary manslaughter. The prosecutor has alleged 2 separate theories of defendant's guilt, which may be established under either or both of the two theories. The first theory of involuntary manslaughter is doing a grossly negligent act causing death. To prove this charge under the first theory, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, in count 1, that the defendant caused the death of Madison Baldwin. In count 2, the defendant caused the death of Tate Muir. In count 3, the defendant caused the death of Hannah St. Juliana. And in count 4, the defendant caused the death of Justin Schilling. That is, that Madison Baldwin, Tate Muir, Hannah St. Juliana, and Justin Schilling died as a result of storing a firearm and its ammunition so as to allow access to the firearm and ammunition by his minor child. There may be more than one cause of death. It's not enough that the defendant's act made it possible for the death to occur. In order to find that the deaths of Madison Baldwin, Tate Muir, Hannah St. Juliana, and Justin Schilling were caused by the defendant, you must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's act. Second, in doing the act that caused Madison Baldwin, Tate Muir, Hannah St. Juliana, and Justin Schilling's death, the defendant acted in a grossly negligent manner. Gross negligence means more than carelessness. It means willfully disregarding the results to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, we must find each of the following three things beyond a reasonable doubt. First, that the defendant knew of the danger to another. That is, he knew there was a situation that required him to take ordinary care to avoid injuring another. Second, that the defendant could have avoided injuring another by using ordinary care. Third, that the defendant failed to use ordinary care to prevent injuring another when, to a reasonable person, it must have been apparent that the result was likely to be serious injury. As previously noted, the prosecutor has alleged two separate theories of defendant's guilt. The second theory is gross negligence in failing to perform a legal duty. In the second theory, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant had a legal duty to Madison Baldwin, Tate Muir, Hannah St. Juliana, and Justin Schilling. The legal duty charged here is one imposed by law. In Michigan, a parent has a legal duty to exercise reasonable care to prevent their minor child from intentionally harming others, or prevent the minor child from so conducting themselves in a way that creates an unreasonable risk of harm to others if the parent knows that they have the ability to control their minor child and knows of the necessity and opportunity for exercising such control. Second, that the defendant knew of the facts that gave rise to the duty. Third, that the defendant willfully neglected or refused to perform that duty, and his failure to perform it was grossly negligent to human life. Fourth, that the death of Madison Baldwin as to count 1, Tate Muir as to count 2, Hannah St. Juliana as to count 3, and Justin Schilling as to count 4 were directly caused by defendant's failure to perform this duty. That is, that Madison Baldwin, Tate Muir, Hannah St. Juliana, and Justin Schilling died as a result of defendant's failure to exercise reasonable care to control his minor child, so as to prevent him from intentionally harming others, or from so conducting himself so as to create an unreasonable risk of bodily harm to others, knowing that he has the ability to control his child, knowing of the necessity and opportunity to do so. There may be more than one cause of death. It is not enough that the defendant's act made it possible for the death to occur. In order to find that the deaths of Madison Baldwin, Tate Muir, Hannah St. Juliana, and Justin Schilling were caused by the defendant, you must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's act or failure to act. With respect to the alternate theories, it's not necessary that you all agree on which theory has been proven, as long as you all agree that the prosecutor has proved at least one of those theories beyond a reasonable doubt. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you're satisfied beyond a reasonable doubt that he's guilty. Every crime is made up of parts called elements. I've just described some of those to you, and you'll hear them over and over again. And they'll also be in your jury instructions, the written set that you get at the end. Every crime is made up of parts called elements, and the prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that. A doubt that's reasonable after a careful and considered examination of the facts and circumstances of this case. I want to mention that you see cameras in the courtroom. I don't want you to be concerned about those. The video cameras and the still cameras will not be taking your picture at any time. So I want to make sure you know that. A trial follows this procedure. First, the prosecutor makes an opening statement. The prosecutor gives their theories about the case. The defendant's lawyer does not have to make an opening statement, but she may make an opening statement after the prosecutor makes theirs, or she may wait until later. These statements are not evidence. They're only meant to help you understand how each side views the case. Next, the prosecutor presents their evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of their evidence, the defendant's attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Like the opening statements, they are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide this case. The responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. Part of your job in deciding what the facts of this case are is to decide which witness you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on the witness's disability, race, national origin or ethnicity, gender identity or sexual orientation, or religion, age, or socioeconomic status. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth? Or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in the case? When it's time for you to decide the case, you're only allowed to consider the evidence that was admitted in this case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is. I may ask some of the witnesses questions myself. Sometimes I assume if I'm confused about something, someone else on the jury might be. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. If you can't hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand immediately. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I'll rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinion about the facts of the case. The lawyers and I will definitely have discussions out of your hearing. Also, while you're in the jury room, I may have to take care of other matters that have nothing to do with this case. Pay no attention to these interruptions. You must not discuss the case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it's time for you to decide the case, I'll send you to the jury room for that purpose. Then you should discuss the case amongst yourselves, but only in the jury room and only when all the jurors are here. You must not talk to the defendant, the lawyers, the witnesses, or anyone who may be connected to this case. This means that you may not speak to these individuals, even if it has nothing to do with this case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to this case. This restriction is necessary to avoid even the appearance of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, tell them to stop. Explain that you're a juror and that you're not allowed to discuss the case. If they continue, leave. Report the incident to court staff as soon as you return to court. When the trial is over, these restrictions no longer apply. When the trial is over, you may, if you wish, discuss the case with anyone. I mentioned before that it's helpful. I guess I'm hopeful and it's helpful that you wear your badge because that sort of alerts people in the courthouse that they shouldn't be chatting you up. Okay. All right. During the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you must consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth. The lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instructions. The restrictions I'm about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it's crucial that jurors are not influenced by anything or anyone outside the courtroom. Under the law, the evidence you must consider has to meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because information obtained outside the courtroom does not have these safeguards, it could give you incorrect or misleading information that might unfairly favor one side. These restrictions start now, well, really yesterday, and continue until I discharge you from jury service. It's your duty as a juror to decide this case based solely on the evidence that you see and hear in the courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, on television, the radio, the internet, or on social media platforms. You also must not research any aspect of the case during the trial. This means research using a cellular phone, computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, cellular phones, computers, or other electronic devices. You must not visit the scene of any event in this trial. If it's necessary for you to view or visit the scene, court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge you have of the scene. You must not share any information about the case by any means, including cellular phones or social media. This means that even if you're not discussing the case with someone else, you may not post any information about the case on social media websites or in any other matter. If you discover that a fellow juror has violated my instructions, please report it to my court staff. You may take notes during the trial if you wish, but of course you don't have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them during deliberations. You must give them to my clerk when you leave each evening. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. It is possible to replay a witness's testimony upon your request. I think I mentioned this to you yesterday. However, you would be required to hear the entire witness's testimony. You can't fast forward to a certain part and all yell, aha, okay? It's not fair to both sides. You would have to hear that entire witness, all right? There's more than one defendant involved in this matter. You should consider only the evidence presented in this defendant's trial. Each is entitled to have his or her case decided on the evidence and the law that applies to him or her. You can see that there are 15 of you. We have you in 2 different jury rooms just for comfort. After you've heard all the evidence in my instructions, we will draw lots to decide which of you will be dismissed to form a jury of 12. Possible penalty should not influence your decision. If you find the defendant guilty, it is my duty to fix the penalty within the limits provided by law. I'll definitely be giving you more instructions throughout the trial. After all the evidence has been presented, you'll hear the lawyer's closing arguments. Following the closing arguments, I'll give you additional instructions about the rules of law to apply to this case. You should consider all of my instructions as a connected series. Taken all together, they are the law you must follow. After my final instructions, you'll go to the jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It's important for you to maintain an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other
They did,
people
Bob.
based on stereotypes.
Oh, they did?
You may be aware
Yeah,
of some
pictures
of these
out.
biases, though we do not express them. We may not be fully aware of some of our other biases. Take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. All right, so we're going to hear openings. Prosecutor.
Here we go, guys.
Here we go.
November the 30th, 2021, James Crumbley's 15-year-old son walked out of the boys' bathroom in Oxford High School holding a 9mm handgun. James Crumbley's son walked out, he pointed, he aimed that 9mm and fired it 32 times over the course of the next 9 minutes. He fired that weapon at teachers and students. Killed 4, wounded 7, and terrorized the entire community. James Crumbley bought that gun that his son used to kill as a gift for his son 4 days before the attack. James Crumbley failed to secure that gun in a way to prevent his son from accessing it. Anna was 14 years old. Madison Baldwin, she was 17. Tate Muir, he was 16. Justin Schilling, 17 years old. These are the 4 students who never made it home that day. What happened inside that school was truly a nightmare come to life. But it didn't have to. That nightmare was preventable. There are 3 people in this world who are criminally responsible for the deaths of Hannah, Madison, Tate, and Justin. The shooter who committed murder, no doubt he's responsible. But so are his parents. But not for murder. They're responsible for their gross negligence, for involuntary manslaughter. Because that nightmare was preventable and it was foreseeable. The shooter's case is done. The shooter's mother, Jennifer Crumbley, her case is done. You're here to decide the level of gross negligence of James Crumbley. And you will learn throughout this trial that he was the adult out of anyone in the world in the best position to prevent these kids' deaths. You're going to learn that those kids would still be alive today had James Crumbley seized any one of the tragically small and easy opportunities given to him to prevent his son from committing murder. Any one of them. These were opportunities that were literally given to him, yet he disregarded. During this trial, you're going to hear about events from the spring of 2021 to December of 2021. November of 21 is the critical time period, especially November the 30th. But that earlier evidence is going to give you some context. into the family life in the Crumbley household. It's going to give you some context to learn that the shooting didn't just happen out of the blue. The shooter didn't snap. What happened was foreseeable, especially to his father. I'm going to talk to you about some of the evidence that you're going to see through this trial. We'll start with this. This is a 6-hour 9mm handgun. This was the firearm purchased by James Crumbley as a gift for his son on November the 26th, 2021. This is a picture taken by the shooter, found on his phone, the day that gun was brought home. This is a Instagram post from the defendant's son. The next day, November the 27th, 2021. That's after his mom took their son to the shooting range to practice with that gun. Took my new SIG out to the range today. Definitely need to get used to new sights, LOL. This is a post from Jennifer Crumbley, the shooter's mother, the defendant's wife. That same day, November the 27th of 2021. Mom and son day testing out his new Christmas present. My first time shooting a 9mm. I hit the bullseye. You're going to learn that it wasn't just those 2 extra magazines for the handgun in the plastic case that came with it when James Crumbley made that purchase. You see, he was given the tools to make that firearm safe. He was provided a cable lock. It was provided by the manufacturer, by Sig Sauer. It went to the firearm dealer who sold it to James Crumbley. It was for that gun. This is what it looked like the day the gun was purchased, November the 26th, 2021. This is what it looks like now. Still in its original packaging, still with both keys in the lock. It was never used. The decision that James Crumbley made to buy that gun as a gift for his son was made even though he knew that his son was in the midst of total and complete social isolation and had been in a downward spiral of distress that had been going on for some time. You'll see evidence that as early as spring of 2021, the shooter had expressed to his one and only friend that he had asked his father for help. He told him to suck it up. That was in April of 2021. You'll learn that instead of receiving help or intervention of any kind, James Crumbley instead began to take his son to the shooting range, even buying himself a 22 caliber Kel-Tec semi-automatic pistol, and his son a different gun, 22 caliber 2-shot Derringer. That was June of 2021. They would go to the range together on a consistent basis over the next few months. We have evidence of a number of trips, and you'll see some of that. Some of this background is going to shed light on what happened in November of 2021. This is a pivotal month in the Crumbley home. As I said, the shooter had one and only one friend. That was no secret. James knew about that. You're going to see evidence that the shooter and his friend would communicate with each other throughout the day and throughout the night. The level of data on that text message conversation alone dwarfs everything else on the shooter's phone. You'll hear evidence that there were over 22,000 text messages in just 1 year between the shooter and his friend. Those two shared quite a bit with each other. This is the friend that the shooter confided in when he asked his father for help. That friend was taken from the shooter at the end of October 21. He didn't just move schools and go to another town. He was taken out of state without warning, without notice, and without a way to communicate. The impact on the defendant's son was severe. His entire social connection was severed, and James was there to know about it. You see, he wasn't working at that time. From November the 1st to November 9th, he didn't have a job. And when he did work before that, it was from home. When he did get a job on November the 10th, it was for DoorDash, where he could set his own schedule and decide when he did work and when he didn't. It was also during this month of November that the defendant's son began to write in a journal. Some of that is going to be permitted to be shown to you. And Judge Matthews decides what you see and what you don't see. The portions you'll see is that the defendant's son wrote about how he was begging his parents for help, how he's begging for a more powerful 9mm handgun to commit the school shooting, and how he's able to obtain access to the murder weapon. Again, this evidence is important for you as background to what happened on November the 30th, but it also gives you a glimpse into the level of knowledge possessed by James Crumbley when he made the decision to buy that 6-hour 9mm handgun for his son on November the 26th. And then, just as importantly, what he decided not to do the morning of the shooting. You see, James Crumbley was afforded what might have been the easiest, the most glaring opportunity to prevent the shooting. A full 3.5 hours on November 30th before the first shot was ever fired. Because he was shown this. This is a math worksheet. These are drawings and writings from the defendant's son. November 30th, 2021. One of his teachers saw him doing this, took a picture of that, and sent it to the shooter's counselor. The counselor came down and took the shooter out of class, brought him to his office to find out what was going on. You will learn it took that counselor all of 20 minutes to decide that immediate parental intervention was required. He made that decision even though he had about a fraction of the knowledge possessed by James Crumbley.
20 minutes.
You see, this drawing, as well as an altered version created by the shooter, were both sent from that counselor to Jennifer Crumbley, who shared it immediately with James Crumbley before they arrived at the school. The severity of the situation wasn't lost on James and Jennifer Crumbley either. They expressed their concern about what they see here, the words "help me," blood everywhere, a picture drawing of a gun, of a person with 2 bullet holes in blood. They expressed their concern about that drawing to themselves in Facebook messages. This is Jennifer Crumbley, she's in blue. Call now, all caps, emergency. This is November the 30th, 2021 at 9:33 in the morning. Followed simply with emergency. Then she sends her husband, James, the defendant, both the original drawing as well as the altered version of it that the shooter created. That's at 9:38 in the morning. James Crumbley's response, "My God, WTF." And then he says what he was actually doing that morning. "Vet not here. It's McElmurray's for Curious Works. Still waiting on the vet." You see, James and Jennifer Crumbley spent quite a bit of time away from the home, tending to their horses. That's what he was doing the morning of the shooting. Jennifer Crumbley, he said he was distraught about last night. James, we talked about it this morning. You talked to him? Jennifer, can you call? Then heading to his school, I'm very concerned. That was at 10:04 in the morning. Unfortunately for everyone, they kept that private concern to themselves. They didn't share it with the school counselor. Despite what they knew, despite what they thought, James Crumbley and his wife, neither one of them, mentioned anything about the gun being purchased for him 4 days before the shooting. James Crumbley didn't say a word about how that picture of the gun that his son drew looked identical, that you will see, of the 6-hour 9mm. They didn't say anything about the prior request for help. James Crumbley didn't mention anything about the severity, the real circumstances of the shooter's friend being taken from him. They didn't just fail to inform in that meeting, though. They also failed to act. It was recommended at that meeting that James and Jennifer Crumbley get help for their son then, immediately, that day. And they were provided with a list of resources with mental health providers that would fit any budget, any insurance plan, or even no insurance at all. But they didn't. James Crumbley didn't do anything. Jennifer Crumbley didn't do anything. Neither one of them called. They didn't take him home. The reason given to the counselor is that they had to work. But James didn't mention that as a DoorDash driver, he set his own schedule. He didn't mention that he hadn't even signed in for the day for DoorDash yet. He was at the vet. Or that as a DoorDash driver, he was able to just put his son next to him in the car. One of the most glaringly missed opportunities. Instead of seizing that incredible opportunity that was before him, James Crumbley spent the next 2 hours driving around town making deliveries, never once bothering to stop by his house, which was just a mile away, to check on the whereabouts of the gun that his son drew. Even when he drove by the house to do so, never once. The gun that he knew was kept unsecured. That is until after the Oxford School District sent out an email blast to all district parents of an active shooter situation. You'll learn that that email reached James Crumbley at about 1:10 p.m. And by pure happenstance, James Crumbley was at the exact location that parents of Oxford high school students were told to go in case of emergencies. Their reunification point was the mire on Ray Road next to the high school, directly adjacent to it. By pure coincidence, he happened to be at the exact location where hundreds of people were scrambling to get to. But he didn't stay. That's when he went home. That's when he went home to look for the gun. And that's because he knew. You will hear that there was one and only one person who called the police that day to identify their kid as the suspected shooter. It was James Crumbley. This nightmare, these murders were preventable by him, foreseeable by him. During this trial, you're going to hear from between 15 and 20 witnesses. I do need to tell you that you won't hear from the shooter. Neither side is entitled to call him to the stand. You won't hear from Jennifer Crumbley. Again, neither side is entitled to call her to the stand. But you will hear a lot about what happened in the days, the weeks, the months before the shooting, specifically November the 26th and November the 30th. Again, those are the critical days. What happened from the 30th, from the time of the meeting to the time that first shot was fired. You're going to learn that throughout the investigation, investigators obtained information from social media accounts, from cell phone forensic analysis. They obtained banking records. They obtained GPS pings. So you're going to be able to put together a bit of a digital footprint of the Crumbley life. You're also going to learn what James and Jennifer Crumbley did after the shooting. Evidence will be presented to you to show that the defendant and his wife withdrew as much cash as they could. They tried to liquidate their assets. They were found hiding from the police in the city of Detroit in an art studio on December the 4th, 2021. That's after they were charged with these crimes. Which you will never hear, and I want to make sure this is clear, you will never hear any allegation that James Crumbley knew what his son was going to do on November the 5th, that he bought the gun knowing what his son was going to do. If he bought a gun knowing his son was going to commit mass murder, then he'd be charged with murder. There is no claim that James Crumbley gave his son that firearm hoping he would murder more students. So then the question becomes, how is it that a father can be held responsible for the intentional acts of a teenage son? And the answer to that question is twofold. There's two reasons. First, it's important to remember that James Crumbley is not charged with murder. He's charged with involuntary manslaughter. Murder, or aiding and abetting murder, is an intentional crime. Involuntary manslaughter is rooted in negligence. It is by definition causation an unintentional killing. Second, it's because it takes a rare and specific set of circumstances to rise to the level of involuntary manslaughter when there are multiple causes of death. A rare set of circumstances. Those rare circumstances you will find present in this case. It takes gross negligence. It takes causation of death. And it takes that other person's acts to be reasonably foreseeable. Those are the three elements that must be proved. And that's what Judge Matthews is going to tell you. You will learn that the law says that in this situation, there are actually two different ways to find this defendant guilty of involuntary manslaughter. You're able to pick either because the law allows you to do so. Involuntary manslaughter is committed when someone's actions or inactions are grossly negligent, or their failure to perform their legal duty as a parent was grossly negligent. That gross negligence caused death, and not the cause. It was a cause of death. And that's important because the judge is going to tell you that there may be more than one cause of death, such as this situation, as long as that other cause was reasonably foreseeable to him, to the defendant. Not to everyone else in the world, but to him. The father who bought the gun, the father who raised the shooter, the father who knew what was going on in his life, the father who suspected him as a school shooter, well before his name was made public, well before anyone from the police department told him it was his son. The law allows multiple people to be held responsible in this case. And that's going to come to you from Judge Matthews. Gross negligence is the failure to use ordinary care to avoid a known danger, even though it was apparent to a reasonable person that serious injury would result. It's the willful disregard of danger. And that, ladies and gentlemen, is why we were here. James Crumbley's willful disregard of danger and his failure to use just ordinary care, when he was the one who knew the background, he was the one that knew the origins of this drawing. Him sitting in that counselor's office, looking at this drawing, and then not only staying silent, but then his failure to act, right there is his willful disregard of danger, right there. You're going to hear a lot of evidence and arguments in this case. It's important that we all understand that you're not here to talk about, to decide on parenting. This case isn't about parenting. It's not illegal to be bad parents. It's not kids doing kids things. We're here to talk about a preventable mass murder. No one will ever suggest to you that every parent can or should be held responsible for everything their teenager does. That's not the law. No one will ever suggest that to you. But in a situation where the father was in a position to reasonably foresee what the son was going to do, because the father armed him 4 days before and was shown a clear statement of intent of what the son was going to do. That is when that rare set of circumstances is present, in the specific set of facts. James Crumbley is in charge with what his son did on November the 30th. James Crumbley is charged with what he did and what he didn't do on November the 30th. That is a very important distinction. That is what the law allows. That is what we were asking you to do. This case is not about guns. It's not about even how all guns should be stored in the home. It's not about gun laws. This case is about this gun for this kid with these issues, not secured, when shown this picture. That's what this case is about. When this kid was begging for a more deadly weapon, that's why we're here. I ask that you listen to the testimony, you review the evidence, and you follow the law. If you do that, you will undoubtedly reach a fair and just verdict. If you do that, you will find that James Crumbley is one of the 3 people in this world criminally responsible for what happened on November the 30th, 2021. You will find him guilty as charged.
Thank you, Mr. Keys. Ms. Lehman, would you like to make an opening statement?
Yes, Your Honor. Thank you. The events of November 30th of 2021 undeniably changed people's lives in ways that most people could never imagine. 4 children lost their lives. Families were destroyed, and a community was terrorized. But this case is not about what happened inside of Oxford High School. This case is about what happened outside of Oxford High School. The prosecution alleges that James Crumbley was aware that his son was a danger to others, and that he failed to protect other people from his son. The prosecution alleges that James Crumbley had knowledge that his son could and would hurt other people, and that he failed to protect those people, that he failed to take steps to protect others. And ladies and gentlemen, that simply is not true. You will hear evidence in this case of what occurred inside of Oxford High School. You will hear the prosecution's version of what they claim James Crumbley may have known. You will hear that a gun was purchased on November 26th of 2021 by James Crumbley. You will hear what kind of a gun it was. It was a handgun. You will hear how it was stored. You may hear where it was stored. You will hear whether or not Mr. Crumbley's son knew where that firearm was. Pay attention also to what you don't hear. Pay attention to that you won't hear that James Crumbley knew that his son knew where that firearm was. Ladies and gentlemen, James Crumbley was not aware that his son had access to that firearm. You will hear testimony that access was not allowed in James Crumbley's mind. Ladies and gentlemen, you will not hear that James Crumbley knew what his son was going to do. You will not hear that James Crumbley even suspected that his son was a danger. That math homework that the prosecution is putting up on the screen, you're going to hear about that. You're going to hear about what other people thought about that. People at the school, including James Crumbley. There's going to be probably quite a bit of discussion about that piece of math homework, ladies and gentlemen, and you're going to hear all about it. Ladies and gentlemen, James Crumbley did not know what his son was going to do. He did not know that his son could potentially harm other people. He did not know what his son was planning. He did not purchase that gun with the knowledge that his son may use it against other people. You will not hear that he did that. The prosecution told you that. The prosecution just told you you're not going to hear that. You're not going to hear that James Crumbley purchased that gun with the knowledge that his son was going to go harm other people. But what the prosecution wants you to believe, the part that's not true, is that James Crumbley knew what his son was going to do and knew that he had a duty to protect other people from his son. Ladies and gentlemen, that's not true. He didn't know. You're going to hear about James Crumbley's relationship with his son. There may be other witnesses who testify about that, about how James interacted with his son, including on the day when that math homework was shown. You're going to hear from other people. They're going to tell you, in their own words, what they observed about James Crumbley and his son, about what they observed about his son, about any concerns they may have had. Other people, not just James Crumbley, but other people with additional education, additional training to evaluate situations like this and evaluate individuals. You're going to hear from those people probably. And they're going to tell you in their own words what they thought about the math homework, about Mr. Crumbley's son, about Mr. Crumbley's interactions with his son. Yes, James Crumbley was a DoorDash driver. We all know that. It's been said multiple times. Ladies and gentlemen, being a DoorDash driver doesn't mean that your job is any less important to you or other people than any other job. It doesn't mean that you don't feel that you have a duty to go to work. And ladies and gentlemen, when you're not aware of an immediate, imminent danger, why would you do anything different than what you normally do? You wouldn't, because you don't have any reason to think you need to. So ladies and gentlemen, you're going to hear the evidence. You've heard a lot of questions in the last couple of days from both the prosecution and myself. You probably have an idea where each side lands on these issues. but you're going to hear the evidence. You're going to hear from people other than us. And you're going to be able to hear in their words what they thought about those days from November 26th to November 30th of 2021. And their feelings, what they observed, any concerns that they may or may not have had. The prosecution has asked you repeatedly to follow the law. I'm going to ask you to do the same thing. Please do follow the law. And I'm confident, we are confident, that if you do that, if you follow the law, that you will find James Crumbley not guilty. Thank you.
Short and sweet.
Thought they both did a good job.
Yeah. Short and sweet.
You might have to do a little bit of setup when you quote them, and then you're gonna be able to-
I predict that this attorney will not be taking the type of heat that Shannon was taking during
Yeah.
Jennifer's trial. Whew.
No Taylor Swift lyric there.
Yeah, I liked her, but she rubbed people the wrong way. I think she'll probably be much more I guess you'd call her traditional, more Shannon was not your traditional defense attorney in terms of how she was handling it. Yeah, Amy, she was and she wasn't. Like I've explained multiple times, she was handling that case without anybody helping her, like a trial partner. Like Allison and I always tried cases together because one person trying to sift through mountains of evidence when the state's going through its case in chief is very difficult to do. So she was definitely she was under a huge amount of pressure, and just the mechanics of that is very, very difficult. Like I think people don't think of things like that, but those are facts. And I mean, she owned that in the closing. So I was shocked that she was doing that trial alone, because like in the first couple of days, she had a guy sitting with her. I don't know who he was. And then he vanished. And, she had this mountain of files that was on the end of the table. And like when the state's going through their witnesses and they're talking about exhibits that they're going to be introducing, the defense attorney has to be trying to pull out their copies of it or find it on the computer so that you can reference it while they're going through the cross or the direct, whatever the case may be. So she's trying to do those two things while listening to the witness to make the objections that she has to make. And again, objections have to be made at trial, because that is what locks in appellate issues. If you don't object to certain things at trial that need to be objected to, it's waived for the purpose of appeal. So I know objections and sidebars irritate people because it can, disrupt the flow, but it's mandatory. Like it's part of our job. It's one of the primary reasons we're in there. We're trying to make sure that a fair trial is happening. Part of that process is making sure that you're objecting to things that you think or you believe that the law doesn't allow for it to be admitted into evidence, or statements that are being made. So that's why you hear objections happen all the time. It's like there's an old saying, if you happen to fall asleep at counsel's table, the moment you wake up, the first thing that comes out of your mouth should be objection. So I was doing an election case. It was an interesting case. My dad's old partner was an election lawyer in Chicago, as you know, was a very toxic election town. It's a lot of scandals and things like that. So they were filing for they wanted a recount of the election for this particular office, and I was in the process of deposing all of the jailers that worked at Cook County Jail, all the employees, because we were alleging that they weren't giving pretrial detainees who've not been convicted yet and still have the absolute right to vote, that they weren't allowing them access to the polls. So, they were long hearings, and I was cross-examining all these guys. My dad's old trial partner was he's probably like in his mid 60s, maybe early 70s. And I looked over and he was sleeping. And I'm like, hey, Mike, wake. Like I've been like deep into a trial where you don't get much sleep as a lawyer, I've definitely been drowsy, like in late afternoon, like if it's like an expert witness and you're just kind of sitting there like listening and you're trying to pay attention, and you can feel your eyes, that feeling when your eyes are getting heavy and you're really fighting to keep them open.
Yep.
I've been there a couple of times. I've never flat out dozed. There's been plenty of jurors that have dozed, especially nice older jurors. They like to take little naps during the trial sometimes. It's like, and then you're like, hey, Your Honor, you wanna wake that juror up? So I thought that the openings were succinct, quick. That's what we want to see. I think that bodes well. The hope here is that they'll play a little more nicely with each other than they did in Jennifer's. Like Shannon and her male counterpart had a very toxic relationship in that first trial. It was like he was very snarky with her, and I think that her personality and kind of how she was trying the case irritated the shit out of him, and he wasn't hiding it well. So hopefully with this trial, we'll get some highly professional performances by the attorneys in this case. But and I just wanted to bring up, because I had seen it in various formats on socials yesterday, talking about this case moving forward. And they will certainly be talking about the school shooting. And the reason that they do that is that even though this isn't a murder charge, again, remember, it is a homicide charge. So it falls under the homicide statute. And again, remember, you have murder in the first degree, second degree, voluntary and involuntary. Those are all homicides. They fall under a homicide statute. One of the elements of a homicide statute is that a human being lost their life. Now, every case that you see for murder or anything under a homicide statute, the state has to establish that there was a human being, number one. That's why you'll see proof of life type evidence to show that the victims were once a living human being. Proof of death evidence, which shows that they lost their lives, in order to establish that element of the crime, which is that a human being lost their life. So that's why we're going to hear a lot about the shooting itself, which may not seem like it has much relevance to these trials, but it does, because of that very fact that they have to prove up that element of the statute. So whether or not they'll do quite as much as they did in Jennifer's, they had a lot, Jay. I know you weren't streaming it, but they had quite a bit of evidence about the shooting itself. And the other thing, if you'll notice, they're never using Ethan's name. They call him the shooter. And that was by agreement of the parties, that they weren't going to reference Ethan, because the rationale behind it is that everyone was concerned if they kept using his name, that would be unfair, in the sense that it would impart guilt onto the parents, because of his acts were so horrific and outrageous, that they were concerned that constantly using his name or referring to him as their son, that would unfairly affect the jury in terms of bias. So that's why they're just doing referring to him as the shooter. And again, that was something that was figured out pre-trial. Amy, let's see. Amy P had asked a question here.
By the way, while you find that, I can already see, and we talked about this before. Bob talked about this. There are definitely strong opinions on both sides, and me and Bob both run our channels that we absolutely want, opinions. We want people to, but all we ask is that you be respectful. We know that not everyone's going to agree on this, and we know you guys can do it. I don't have to preach to the choir, but just always try to keep it respectful. Try to keep it kind. We know this is definitely a case where a lot of people are on both sides, so we appreciate you being here. We appreciate you being respectful of everyone. That's all we ask for. We don't expect everyone to agree on this.
Yeah, and this is that case, and I was very proud of our subs and people that were streaming that with us when we did Jennifer's trial. People really stepped up. Use your words. You can use there's words that you can use if you have an argument. You can make a cogent civil argument to get your point across without divulging into names. If you get into name calling, then you probably need to open up a dictionary, start reading some words, and figure out a way to impart what your thoughts are without insulting other people, because that is just not an effective way to win an argument. I guarantee you will never win an argument by calling somebody a shithead. It'll never happen. However, if you have a cogent, intelligent argument, you may convince somebody someday. That's how arguments work. And this case is every bit of that, because this case intertwines a lot of things. We can't deny the fact that there's Second Amendment issues that are intertwined with this. We can't, the fact that essentially, if he's convicted as well, that puts every parent in this country on notice that you can, moving forward, and will be held responsible for your kid's actions if you knew or should have known what was going on in your kid's life. And it's a scary prospect. And, me as a parent of 4, I'm very involved with my kids. I know what's going on with my kids. And that is the standard that I hold every parent in this country to. So, and I'm a defense attorney, it's like, to me, if you're going to go ahead and have kids, do the job. And if you're not going to do the job, well, there's going to be consequences at the end of the day, especially if something as horrific like this happens, which to me, and I appreciated them harping on what I feel is the most smoking gun piece of evidence, which is that math test. And when you see, and he didn't even mention, it was up there for the jury to see, but, I can't stop the thoughts. And right underneath that, help me, and then you see what his thoughts are drawn out on various pieces in various parts of the paper. And it's like, I just don't know as a parent how you see that and don't take immediate action. And I've said a million, I don't care what the school was saying. It didn't matter. It wouldn't have mattered to me if the school said, well, he can say here, it's fine. We think it's an anomaly or whatever they may have said. It wouldn't have mattered to me as a parent. If I see my kid had written something on a math test, which he knew was going to be turned in, this is a test. You guys remember back in high school, they'd hand you the test, you'd, fill it out, you'd do the test, and then you'd hand it back up, or the teacher would come and collect it. He knew that was an absolute cry for help. If the 2 words "help me" are not a cry for help, I don't know what is. So for me, that piece of evidence alone was enough for them to have pulled their kid out of school immediately. If it's me, Jay, I'm taking my kid and we're sitting in the car immediately, and I am having a very long, in-depth conversation to find out what is going on with my kid. There's in any parent that's not doing that, when they see that, you shouldn't be a parent. You just shouldn't.
And you're probably like, where's the gun I bought you?
For sure.
Right? I mean, not that I would buy a kid a gun, but you're probably like,
I'm opening the backpack, dude. I'm like,
right.
you know where the gun's at. It can only be, if it's not on his person, it can only be in one place, and that's in that backpack. No one in that office, when they were sitting there, and I'm talking about a counselor, the vice principal, Ethan and his parents, 5 people in there, 4 of which were adults, not one of them opened up the backpack. And while some can argue, okay, well, the school, you have a very your expectation of privacy in school is diminished massively because of all these school shootings in terms of what the school can and can't do. They are not law enforcement. They didn't need to worry about whether or not, if they had opened up the bag, if something was going to get suppressed. That only happens when law enforcement violates the Constitution, not when private citizens do. So anybody could have opened it. The parents certainly could have. I mean, there's not a world that exists where I'm not putting together, looking at that paper, and then opening my kid's backpack to see, like, instantly. I'd be like, I would have said, give me that backpack. And I would have opened it up, and it would have been like, because at that point, I'm not worried about anything other than finding out what's going on in that moment. I'm not worried about, oh, well, is my kid going to be in trouble? Well, your kid needs to be in trouble because he's off the rails. And more importantly, your kid needs help. He needs help, and you're not giving it to him, So for me, if this doesn't go the exact same way, I'll be stunned, to be honest with you. Like, Alice and I were both, I could see a world, like, I actually thought that Jennifer's trial would end in a hung jury or a mistrial because of the nature of this case, because of what we will end up seeing in chat, where it's a very divided issue, where you will have people that are saying there's no way parents should be charged for this. Like, so now we're going to be charged for every crime that they commit. And it's like,
Right.
that's not what they're saying.
I get that, and then the argument is the precedent. This is setting a precedent for every. But like, I think the point with this case is, I don't think we're saying that the precedent that's set is that every parent has to know every single thing about what's going on in their lives. It's just impossible when they're teenagers. They're going to have stuff on the phone you don't know about. I mean, you're going to do your best, but the difference with this case is, like you said, Bob, that fucking test. And also, they bought him a gun. If you're a parent, that, like, it's the minimal amount you could do as a parent. If first of all, don't buy him a gun. But if you're gonna, because I think you can't do that anyway. But if you are gonna buy a gun for your kid, they have a gun. They call you to school, and like I talked about this with Jennifer, I have never been called to school ever for my kids. I mean, I'm sure there are some issues where you get, but if you are called to the school with, like, that is a serious issue. They're not just calling someone for nothing. So they call you down there. They show you this test. They show you the gun, the feelings that he's having. He has a gun. The minimal amount, then why this case is here, is you fucking check on that kid. You get the gun. You do something. You don't do nothing. And I think that's go ahead.
Yeah. No, man. I mean, absolutely. Look, like, we have 4 kids, 2 of them are grown at this point. Our second wave, we've got a 17-year-old. And, we were teenagers. I know how I was with my father and my mother in terms of when I was a teenager. Kids begin to rebel when they're figuring their shit out. You're figuring out everything that life throws at you. You're figuring, your hormones are raging. You're going through puberty. You're getting into your first relationships. Your boyfriend or girlfriend is breaking up with you. You're going through all kinds of trauma with that shit. You're having arguments with friends. Is this person my friend? All that shit that comes along with being a teenager. And, they're just young humans. Like, the term kid is like, to me, like, I treat my children, I speak to them as if they're adults, because I know they're smart enough to understand what I'm saying. I never treat them like children. And I always know that they have every single right that I have as an adult. I have to try to guide them through the best way that I can based on my experiences in my life. I'm very open about shit that I fucked up during the course of my life with my kids. Allison's always like, why the fuck are you telling? And I'm like, I'm an open book. I just am. It's like, I've done this. I've experienced this. I screwed that up. Let me impart some knowledge on you so maybe you can avoid doing the same thing, and that's just how I parent, and I realize that not every parent's going to parent the same way. We all have different techniques. But communication with your kids is unequivocal. Every parent needs to be communicating with their kids. Like you said, Jay, like, I never was going in and digging into my kids. If, like, Cameron has a journal, I'm not going in and spying on her. I respect her right to privacy, because, again, she's just a young human being. Human beings, we have rights, and that being said, I can tell if something's off with her, like no matter what, she's 17. If it's that time of month, I'll know if she's being a little bit bitchy to me, that it's probably that. if it's more than that, I'm aware of it. You know, I can feel it, I can sense it, and I go to her. I'm like, "What's going on? You know, talk to me." You can tell, and if it's something you don't want to talk to me, talk to mom. You know, just let me know what's going on. And they had enough to know, you know, that their kid just being observant. They could see that their child was a bit of a loner. Like he had one homie, like, and that kid moved away. You know, so this kid is now friendless. And Jay, you've got kids. You know, like when your kid doesn't have a child or doesn't have a friend, and they're kind of a loner, you know, it concerns you. You know, like when my kids were young, if there was like even a phase where it seemed like, because they're depressed about it, they want to be out hanging out with friends. They want to have friends that are calling them or coming over to the house saying, let's do stuff. And when that doesn't happen, that is going to, it's absolutely going to eat away at you as a small human being, because we all have feelings and emotions, and those things are running rampant with kids when they're learning how to be an adult. You know, as all this is coming at them in waves. It's like anybody who remembers being a child is, and a teenager especially, remembers how difficult it was, especially in high school when you're dealing with cliques and you just feel like, and if you're like a kid who's feeling like that, or an outsider, you just have to know what that kid's going through, you know, and it bleeds into like the bullying stuff, and it's all intertwined. And it's just, when they were handed that piece of paper and they made that decision to allow their child, for whatever reason, he's claiming he had to go drive for DoorDash. Bullshit. There's nothing that takes precedent over your child ever. I don't give a shit. I could be in the middle of a trial, and if I got a call from the school in the middle of the trial, I'd step up in front of the judge and I'd say, Your Honor, I have a family emergency. And if the judge says, well, we're in the middle of a trial, I'm going to say, tough shit. This takes precedent over everything else, you know, and I'm going to handle my business with my child, and I'm making, because like protecting my child is my primary job in life. Nothing is more important to me than my children. Nothing, not jobs, not money. I don't give a shit about anything else. Everything falls to the wayside. My kids are my entire purpose of living. You know, for me, making little people was like, that's the thing that we do. That's the reason we exist, because I don't believe we exist in the world to go work and make fucking money like that. Like going to some job every day just so we can make money to pay bills seems frivolous to me. Like it's a necessary evil for all of us. We all have to do it, but that's not what life should be about. You know, life is about family and relationships and friendship. Like that's what it's all about, you know? So, you know, anybody who's putting anything ahead of their child when they're handed that note, they're culpable in my world. And we see what the end result was. The end result of this was beyond tragic. If I were the parents of any of those victims of the shooting, I would be sitting there in that courtroom, just shooting darts out of my eyes at James Crumbley and meaning every bit of it, because I'd be putting it on his ass. I'd be saying, you know what? My kid's dead because you didn't do your job. You didn't fulfill your duties as a parent, period. And that's just how I feel about it. And if it scares people that they can be held liable for, you know, the criminal actions of their children, well, then do better. Be better. Then you don't have a problem. Be present as a parent. And that's it.
I mean, it was like willful. Like, you looking at that, you had to, like, you are trying not to see what's there. It's willful. Like, how could you not? I mean, I guess I'm just making the same point. But if you see that, you have to be trying not to help. Like, you have to, like, fuck, I don't give a shit. Like, I don't care about my kid, and I don't care about anyone else's kid. I don't care about anyone else out there in the universe, because I know I bought them a gun, and I know they have problems. And like you said, Bob, handing that in, it's not like he's hiding this test, and like the teacher's like sees him scribbling we got some movement. So, but he's handing that in as
he knew. He knew that the teacher was going to see it. He knew that it would get to his parents. He knew. You know, this kid, like when we start seeing his disturbing journal entries. This kid was bright. Like, he had deep thought. He was thinking about all kinds of shit. And I'm telling you, if y'all haven't seen his journal entries, and I suggest everybody watch, the hearing that took place in his case, it like where they really, they put it all out there, man. It is beyond disturbing. I mean, this kid he was mentally damaged. He was just spiraled. You feel so like everyone failed that kid for as much of a monster as he turned out to be. It's like, I blame everyone around him for failing him. It's like, again, he's a 15-year-old kid. Their minds are not developed. He did very adult things when he committed those crimes. So it's hard for us to delineate the fact that he's a child with an undeveloped mind because he's doing adult type crimes. And but he's a kid and he needed help and he just got nothing from nobody. And it's rough, man. It's a rough case, but it's such an important case. Like it's like something in this country has to change. I'm not trying to take, people's guns away from them. The purpose of the Second Amendment is important. The reason that it exists, if you know anything about constitutional law, if you know anything about the history of our country, it exists because we cannot be unarmed if the event occurs that we need to protect ourselves from our government, which, believe me, it happens. It happens. That's why we have it. That's why we have the Second Amendment. It's not so people can go, commit crimes and have all that. It's so that we're armed in the event that we need to raise arms up against our own government because they've spun out of control. Like, that's why the Second Amendment. So I'm not trying to say, let's get rid of the Second Amendment. What I'm trying to say is we need gun reform. Like if you have kids and your kids are sitting in schools and they're having to go through active shooter drills and you don't have an issue with that, I can't help you. I cannot help you. We will never agree on that. The fact that my kid has to worry about being shot to death while they're in school is never going to be okay with me under any circumstances. And anybody who thinks that, yeah, I don't know, man.
I just think about the kids in I guess it's like the bomb drills they used to do back in the day, atomic bomb, but like these kids in preschool and first grade, like in elementary school, are practicing, and they have to they know that they're doing these drills where they're hiding under desks and they're closing shit because of someone coming in to shoot. Could
you imagine that, dude? Seriously,
it's
crazy. How can that be the new norm? Like when we were kids, dude, it was like, you guys might have had hurricane type shit. Like we had tornado drills, it's like, right. Okay, get under your desk. Now it's like you're sitting in a hallway, putting your head between your knees and or whatever they're doing with these active shooter drills. It's like the thought that they now have to think about the possibility that there's going to be somebody with a gun walking through their school trying to kill them is so upsetting to me. It's like it's like we've stripped away the innocence of youth just in general with the fucking social media and all the bullshit that's out there, just torturing young girls, like having to look at all these fake Instagram bullshit. And that's what they think that they have to look like. And girls are already going through so much when they're growing up. And it's a lot, dude. It's a lot.
Really is. It really is.
Your Honor, calling People versus James Crumbley, case number 22279-989 FH.
Thank you. Good morning, Mark Hughes on behalf of People.
Karen McDonald. on behalf of the people. Good morning, Your Honor. Marielle Lehman on behalf of James Crumbley, who is standing to my left.
I'm ready for the jury.
We are, Your Honor.
By the way, Bob, do you have a plane to catch? When do you have to go?
Yeah, I'll probably hang for the first witness and then I'll bounce. I got to jump in the shower and get packed up. And then, yeah, I got to get to the airport probably by about 11:20. Yeah, my flight's at 1:20. So get there a couple hours early. It's about a 40-minute drive. I'm excited about what I'm doing though. Like getting to go into the lab.
Cool, man.
It's gonna be cool, dude. And plus, when I'm there, my crime con girl's gonna be there, so I'm getting in her ear. Did you submit your thing to
Yeah,
crime con?
I didn't make the cut.
No, don't worry about that.
Because they already they're already doing the
No,
announcements.
no. They'll add on. Don't worry about that. Your boy's gonna be working it in person.
Nice,
So
dude.
I'm serious though. Like Elise she's my homie, and she's the one who makes the decisions, and she's gonna be there. So I'll be working it.
Cool. Thank you.
Yep.
By the way, thanks everyone for being here. We really appreciate it. Again, if you're subscribed to one of us, not the other one, go subscribe, please. Defense Diaries, if you're on my channel, please check out the podcast, check out the YouTube. We'll share those links. Check them out, please.
Just like a jazz fest. Pull it up.
You know, by the way, I just shared Bob's link tree and his YouTube. Check out the podcast. You know, if there's something with Delphi, if you follow Delphi and you're on my channel and you want the best info, make sure you're subscribed to their YouTube.
And that's for sure. And our podcast, like everyone needs to be listening to our podcast. If you like anything that I'm saying during any of my live streams when I'm on with Jay or on our channel, our podcast, I think, is the best in the game if you like true crime and if you like deep dives. And with Allie on the docket, that's where we're covering current cases. But the podcast is great. It really is. And I don't feel weird saying that, like patting my own back, because it's a great podcast. The Gacy thing and the Garcia thing are epic. I mean, I'm at episode 51 of Garcia.
Oh, shit.
No one does. Well, beyond that, no one does seasons that long. I mean, some people don't like deep dives like that. Yes, there was Manda.
MOLLYDARNELL.
She testified the first trial.
Okay. And Molly, I know you testified a couple times. So, keep your voice up. And if you want me to slow down or you don't understand the question, just let me know. Okay. Can you tell the jury what you do for a living?
I'm an educator.
And where are you employed?
I'm employed at Oxford Community Schools. I've been there since the fall of '98.
So
This poor witness has to relive that nightmare day multiple times. Like she testified at
My
Ethan's
role now
and Jennifer's,
is I am
and
a
now
virtual teacher with Oxford Virtual Academy. I'm a mentor teacher for middle schoolers.
Virtual, that makes sense.
You go to the high school now?
I do not. No.
All right. Can you tell the jury what your role was and which building you worked at on November 30th of 2021?
On November of 2021, I was the International Baccalaureate Coordinator for the Middle Years Program, which was a 610 program, as well as the English Language Arts coach, which was a 612 position.
Okay, so you didn't have, did you have instructional contact with students, or was
I
it
did
more
not.
teachers?
No, I worked with teachers, predominantly the English Language Arts department, but I worked with many other teachers throughout the 612 curriculum. It was it's a coaching job, so instructional curriculum, that type of what's happening in the classroom at that point in time.
When was the last time you had a traditional teaching schedule?
A traditional teaching schedule. Might have been 2015. I'd have to really go back and look at my resume to know that.
Okay.
But in the fall of 2020, I did have a classroom. We went back face to face. And so we pulled all of our instructional coaches out to teach a few hours of the day so that we could spread students throughout the building and get students back instructionally.
Okay, so after COVID, the coaching faculty
We moved back into our
started to take more teaching assignments so that you could spread kids out.
Correct.
Do I have it right?
Correct.
Okay. On November of 2021, were there kids in the school that you knew? And if so, how did you have contact with them?
There were kids that I knew from the class that I had had the previous year. There might have been, having been in the district for a long time, there were a lot of teachers who had children that were in that building. So I know a lot of them too.
Yeah. See, she's gonna get emotional. It's like, dude, this is brutal.
I'm glad you brought that up. Does Oxford have a lot of faculty who send their children to the district?
Yeah, I would say many of our faculty send their
Poor woman.
students through Oxford schools, yes.
Okay. And the kids that you knew in that building that day, did you also know them from middle school or just you?
Yeah, just knew them from knowing their parents, and or if I had them in class the year before. There might have been a kid in passing that I met here or there, but for the most part on that year, I had no contact with students other than, you know, if like a kid wanted to stop in and see me, or if we met in the hallway, or.
Okay. But did you have a traditional classroom on?
I did not. I shared an office. It was like a half classroom.
So was the classroom turned into 2 offices or an office?
Correct. It was a classroom turned into 2 offices. It was in one of the instructional halls, the math science instructional hall. And I shared it with 2 other coaches in the district.
Okay. You're the first witness. So the jury has not seen a map of the school. So I'm going to put that up in a minute.
Okay.
It's already been admitted. There's no objection to that. But before I do, can you just generally describe how the school is laid out? It's a fairly new building, correct?
It is fairly new. The main part of the building was opened, I think, in the fall of '98, the year that I started with Oxford schools. And then I think it was the fall of '04 that we started, that it became the high school. So it's a fairly new building. There is like one main hallway that kind of runs up the center and it hugs into the courtyard. It almost reminds me, like if you opened it in a map, you would see it almost mirrors itself in many ways, especially the area that I was in.
Okay, and your hallway were the hallways organized by subject matter?
Yes, we had like our foreign language hallway, our English language arts hallway, we had our math section, social studies, and then science wrapped around the side. Our electives were on the outskirts of the high school.
And how did the students and the faculty refer to bathrooms and exits? How did they describe them from one to the other?
It might have been like the exit by the staff parking lot. That's how I knew them.
Okay.
I know that there are numbers on all the doors. Numbers are not my thing.
Where's this? Is there a senior?
There is a
leisure
senior,
area
yes.
at Oxford.
Yes, so right up that main corridor, which is like, I said, if you folded it, there's like this one main hallway. Right in the center of the building is considered the senior window. And that is right in front of our courtyard, one of our courtyards.
And the hallways go subject matter. Did you typically find upperclassmen, lowerclassmen, or it was all mixed in all throughout the building?
Well, many of the seniors did hang out in that area, or kids throughout the building. There was no area specific for like freshmen, sophomores, juniors, seniors.
All right, I'm going to show you now and the jury what's been admitted and marked as People's Exhibit 9.
Can I get this?
Yes, it should.
Can I do?
You just take 6 seconds.
Yep. Oh, okay.
That was on the list. It'll take a second.
Perfect.
See it?
Thank you. Yep.
Can you tell the jury what we're looking at?
This is a map of the high school. And so you see where that it says media center in the middle and then court right below it. When we were talking about that senior window,
Right there?
correct? So that senior window is just south of court. Like that's the senior window, that window that is on the south end of court. No, go back. Yeah, right on like the south end of court. Sorry, south.
Okay.
Maybe I'm directionally challenged.
I think.
I'm sorry, I am.
Everyone has
I'm gonna
this.
want to go north.
Okay, so what,
I guess it would be east.
what was the number for your class?
My number is 222.
Okay, right there?
Correct.
Okay. And then what's in the middle area right there to,
Actually, sorry, I'm not 222. I'm 224.
okay.
I was right next door to 222.
Do you see 224?
You can't see the number, but you can see between 226 and 222.
222.
Yeah,
Okay.
there's a bunch of names written in that. That was all the coaches,
right.
myself and the other
And
coaches.
to the left of that, what is that area?
The other room on the other side.
What is this area? What's in there?
That area on the lower end is the science labs. On the upper end, there is I can see a bathroom to the right, a student bathroom. And
And the senior area is up
it's up
in the
top.
middle?
Yeah, it's right there.
Okay.
Yep.
All right. So I want to draw your attention to around 12:50 on November 30th, 2021. Do you remember that day?
I do.
Okay. Did you have any kind of teaching assignment on that day?
I did not have a teaching assignment on that day. It was a Tuesday after Thanksgiving.
Okay. Can you tell the jury about the Oxford lunchtime schedule? Because it's a little confusing.
We run a 7-period rotating schedule, which means that kids meet for 6 class periods a day. The lunches have a split hour, so they have an A, B, and a C lunch. If they're A lunch, they go to their class the second half. If they're a B lunch, they go to class, have lunch, go back to class. And if there's a C lunch, they go to class, then they go to lunch.
Okay, and about how many minutes is passing time generally?
I want to say it was 8 minutes.
And what did you typically do during passing time?
During passing time, I might have gone out in the hall and chatted with a colleague or two, checked in on something. That is also a time it's like the time that teachers need to get things done. So there might be a quick interaction. I might, see a kid in the hallway passing by. But pretty often, like it was just standing guard outside my room or standing outside my room.
Okay. At around 12:50 that day, do you remember what you were doing?
Yeah, a student that I had in the fall of 2020 wanted to chat. And so she came in and we chatted for a few minutes. And then she left.
Do your, as a general rule, do you keep your door open or closed?
Open.
All right. And your classroom, as we see in the map, was smaller. What was the layout of the classroom? Were there traditional student desks in there, or can you explain to the jury what the classroom was like?
If you walked in straight ahead, you would have seen my desk. To the left of that, you would have seen one of my colleagues' desks, and then just on the wall, like closest to the hallway, there was another coach's desk.
What is at the back of the classroom when you go in the front? The wall you're facing, what is that?
There's a large window that leads out to the courtyard.
Okay. Once the student left, what did you do?
There was a few minutes left during passing, and so I walked around to my desk and opened up my laptop.
All right, and we're going
and
to
check some emails. Yeah.
Okay, and are you facing the door, or?
I'm facing the door, correct.
All right, and what happened next, Motta?
I'm sitting on my laptop, reading through an email. The door's open, and I notice a group of kids running by. It was a movement that I had never really seen before. They were moving, like there was a hyperness to the voices. And it was almost like they were pushing forward, like trying to move as fast as possible.
And that seemed unusual to you?
That was very unusual to me, yes.
Okay, why was it unusual?
I have never seen a group of students move like that before.
Because of their speed or the way that they're?
I think it was all of it. There was a speed to it, the tone of voice. There wasn't any like, my first instinct was that it was a fight, but a fight because it was the only thing that, you know, was the closest to what students would be moving quickly or swiftly to, especially in that large group of kids.
Did you stay seated or did you get up?
I got up, I exited the classroom or the office and moved about
In the hallway?
into the hallway. I moved into the hallway to see like, well, what's going on?
Okay, if you look at the map, which direction did you turn? Did you turn
I
towards door
turned
4?
towards door 4.
Okay.
So I turned towards door 4.
What did you see in the hallway?
I see, so the hallway kind of bends. So I come out of my office and I'm closer to that 221, but not fully there, right? I'm closer to 221 and I'm looking and I can see all these kids rushing out of door 4, which didn't make sense to me because, again, I'd never seen this happen.
So that's what you saw.
Mhm.
Did you hear anything at that point?
It was silent. There was no noise.
Was that unusual?
Absolutely unusual.
Okay.
At that time, yes, absolutely.
And what did you do next?
I moved back into my classroom, trying to understand what's happening. And I walk back into the classroom and I'm thinking, okay, could there be a prank? I doubt there would be, you know, and so it's probably 10 seconds, if 10 seconds. And I hear 3 things really close together.
Okay. What did those 3 things sound like?
One was an announcement, the bells chiming, an announcement of our principal coming over the PA and saying, we're headed into moving into lockdown. This is not a drill.
Okay, can you, as a faculty member for this many years, what is lockdown? What have you been trained to know about that? What does that mean?
So we're trained in the Alice protocol, which means we have to use our senses to figure out what's happening. But with all of those students and with what I was hearing, the 2 additional things that I was hearing was like a loud pop, 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 and then multiple doors slamming. I moved to shut my door and lock myself in.
I want to stop for a minute.
Mhm.
What is your experience with firearms up until this point?
Up until this point, my experience with firearms is limited. I have, however, shot a weapon I have in my life shot a weapon.
Okay. Have you been to a range before? Is this a hobby that you have?
It is not a hobby. I have been to a range.
Okay. When you heard the pop, 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 what did you think?
I thought in my head, I could have mistaken them for lockers slamming easily. They did not sound like gunshots to me, but I'm not really, I've been to a range once. I've not, I don't really know what a gun sounds like.
Okay, so what you said, the 3 things, the announcement, the pop, pop, pop of a weapon that I now know, and doors slamming. Okay. What did you do?
I moved to shut my classroom door because when I had come back in, I had not shut it. So I shut that classroom door, and we have a night lock next to all the doors.
Can you tell the jury what a night lock is?
A night lock is a device that slides into the door.
Where do you slide it?
You slide it in the bottom of the door, and it keeps the door. So on my office and all of the rooms in the building have glass partitions on the side. So if someone were to shoot out that and try to get in, it would keep that door from being opened.
Okay, I'm going to show you what's been admitted as Exhibit 10. Molly, what is that?
That's the office that I had.
Okay, so that's your door open.
Yep.
All right, and where is your, this is not a pic, is this a picture that adequately reflects the normal,
No,
like, okay,
this
Um,
was.
we're gonna get to why that's like that, but where is the desk that you were sitting at?
Straight ahead, there's that tall lamp. My desk was. Anyway,
The other way?
Yep.
Okay. So, you said you approached the door, you shut it,
I did. I shut it.
and then where was the night lock?
It is in this photograph. You can see that bag that's mounted to the wall. It was, yep, that's a blood bag that we keep in all the classrooms. And then, or like a medical bag or whatever. And then just in front of that, you can't even see it. It's so close to the door,
Okay,
was the night lock.
okay. And I think I might have interrupted you. What is significant about the night lock and why is it used in a lockdown?
It's a measure, it's an additional measure of barricading yourself into a room if need be.
Can you open the door if the night lock is installed?
You cannot,
What about if you had a key to the door?
wouldn't matter. You cannot open that. It's like, it keeps that door from being opened. You would have to remove that metal frame in order to get that door off.
Okay, and how do you, so the person from the inside has to disengage the night lock, is that?
Yes,
That's
that's
do I have it right?
Yes.
Okay, so, you open it, you close the door and you get the night lock, and then what happens? Did you see anything in the hallway as you approached your door?
No, I didn't. I shut the door. I can hear that door shutting. It's completely silent. And I grab the night lock. And I look down at it because depending on which way your door opens, depends on how it goes into the door. And I see in my peripheral vision some movement. And so I look up, and in that moment, I see someone wearing dark baggy clothes.
And are you seeing him through that window right there?
Yes, it's
Okay.
through.
You describe the person.
The individual is wearing a hoodie, baggy clothes, a mask, and there was a skull cap on, or like a.
So were any parts of this individual's face visible?
I did not see any part. I mean, only his eyes, and he was wearing glasses.
Okay. Had you ever seen this person before?
No.
All right, and when you looked through the door, where was this person? How was he faced? Was he facing you? Was he to the side?
At the moment that I locked eyes with him, we were standing square to one another.
Okay, tell the jury about locking eyes with him and what you saw.
So I lock eyes with this person, and I see some movement coming from the side of him, and I realize that he's raising a gun to me. I remember thinking in my head, there's no orange tip on that gun.
What does that mean?
I had heard somewhere in my past that BB guns have an orange tip. And my body reacted, and I jumped
You're
to the
motioning,
side.
you're
Yes.
motioning that you jumped to the
I
right.
jumped to the right, so I'm jumping this way in the room.
And at this point, the door's closed.
The door is closed, yes,
Is there a window on the other side of this door or just what we
No.
see?
just
Okay.
what you see.
All right, you jump to the right and then.
I jump, I'm turning and I'm jumping to the right, and then I feel my shoulder move back. It feels like I've been stung by hot water.
Okay, you're pointing to something.
Yeah, on
Can
my
you just-
arm,
On your left arm,
yes.
okay.
Um,
At this point, did you manage to get the night lock in already?
no, the night lock's in my hand.
So he could have just opened the door.
The door was locked,
Okay.
like the lock was
Okay.
on it, right? I look behind me and I see, you can see the bullet hole in the glass leading out to the courtyard. And in my head, I remember thinking a BB gun can't do that. The instinct in my body was that I had to barricade this door. But I'm afraid to go back to the door to put the night lock in.
Okay, I'm sorry, I have to stop you for a second. When you, after you locked eyes and you see a gun, do you hear anything?
Nothing.
Okay.
Oh, well, there were, sorry,
That's okay.
there were, it's totally silent in the hallway, but I do hear 3 loud pops. They were, you could feel the force like coming, like the way the door hit, it was very forceful, but the sound did not match the force.
What do you mean by that?
It was like higher pitched than the power of what was happening through that door.
You jumped to the side. You said then you looked and saw the bullet hole, and then what did you do next?
There was a filing cabinet over on the side of the door against the wall, and so it's like a longer one, and so I grab it and I'm trying to move it, and I'm realizing I can't move it, but I know I have to get back and barricade that door.
Okay. You were shot that day.
I was.
Okay. And can you tell the jury and show the jury where you were shot?
Yeah. I'm gonna remove this. Is that okay?
You can step down if you want to. It's okay.
So you can see it's kind of like on the back side of the arm. It's not straightforward. Like you can't see the scar when I'm standing straight forward. So he caught me when I'm jumping on this side. He catches me.
And there's are there
There's an entrance and an exit wound, and the line in the middle is where the bullet cauterized my flesh.
when you were trying to move the filing cabinet, at this point, did you, did you know you were shot?
I did not know.
Okay, were you feeling anything physically?
No, there was nothing physical. I was so focused on, I have to barricade this door. And when I realized I couldn't move that filing cabinet, I still had the night lock in my hand. And so I got down on my hands and knees and I crawled the length of the door and I dropped the night lock in. And it made like ting sound when it hit the ground. And then I went.
Talk to me about why do you say that it made a sound? Was that significant to you?
The only thing that I have to go on right now is what's happening in my space and what are my senses telling me. It just sticks.
Was there anything, could you see, smell, or hear anything else outside of your door?
There was a smell of a cat, like a cat gun might have smelled like. But I'm not going back towards the window, right? I'm just dropping that in. And then I grab the rolling cart, which is also against that back wall, and I push it, and that's what you see in front of the door.
So that piece of furniture is the rolling cart?
Yes.
Okay, and you could move that?
Yeah, it was really easy to move. It was just a push.
Okay. At this point, did you know you were shot?
No.
Okay, what happens next?
I'm concerned that he's gonna come back around to those windows. So I know that I need to hide in that room.
Did you say those windows, the front ones or the back ones?
The back ones.
Okay.
In the back. So I'm trying to, I've barricaded the door. I'm trying to make myself invisible in that space. So I go back to that large filing cabinet and move it just enough so that I can crawl behind it.
We can't see that here because it's to the left, so would you be able to see, would somebody looking in the window next to the door be able to see you?
No, the cabinet was quite large and it was wide. They would not have been able to see me behind that cabinet.
Okay. At this point, did you realize you had been shot?
I knew I could start to feel blood rolling down my arm. And
What kind
I
of?
don't think I was admitting that I was shot, right? It's not some, it was so far out of what I knew to be what happens. And so I just knew that if I was bleeding, I had to put a tourniquet on. But I can't get back to that bag that has medical supplies in it. So I removed my cardigan that I was wearing that day. And I used one of the sleeves to tie around my arm, put part of it in my mouth and the other part in my hand, and I just tightened it around my upper arm.
Are you feeling any pain at this point?
No.
Go ahead, Bob.
All right, y'all. I gotta bounce. I gotta get packed. Gotta head to the airport. I love you guys, everybody in chat. If you're subscribers to Jay, I'm not a guest on here. Jay and I are fam, so I don't know how you haven't run into me. But make sure you sub over to our channel. It's Defense Diaries podcast. We have a lot of great content on there. Jay and I do a ton of stuff together. We're going to be doing this trial together. Jay's carrying the load tomorrow because I'll be in Houston. Jay and I will be back dual streaming on Monday, and we're going to give you the best coverage on this trial, guaranteed. So make sure you're hanging with us. Jay, I love you.
Love you,
Thank
dude.
you, brother. And love you guys all in the chat. Thanks for hanging with us. And I will do a live if I have decent Wi-Fi from the hotel, which is always iffy, on Delphi tonight. It probably won't be a long one. Probably I say that, but then, I can't stop talking. So probably about a half an hour live at some point. Just keep checking your notifications. And if you're following my Twitter, make sure you're following that. Sorry to interrupt y'all. Pay attention to this trial. It's an important one. And Jay and I will be talking about it on Monday. All right. Love y'all.
Good luck with your secret adventures, Bob.
Thanks, Ben.
All right, guys, here we go.
All right. Bye.
The person that you saw raise the gun and shoot at you, did you, looking back then now, what was your impression of his use of the firearm, if anything?
Your Honor, I'm going to object to that question. She's already